Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. The court handed down its decision in First Choice Women's Resource Centers versus Davenport, Attorney General of New Jersey. The opinion came out on April 29th.
And it landed unanimously, 9-0. Justice Gorsuch wrote for the entire court. No concurrences, no dissents. The court ruled that a pro-life pregnancy counseling nonprofit in New Jersey can challenge the state attorney general's subpoena for its donor records right now in federal court, without waiting for a state court to enforce that subpoena first.
And remember from our preview episode, this case drew a stunning 42 amicus briefs on the merits alone, 12 more than Cox versus Sony, groups spanning the entire ideological spectrum. The ACLU, the National Taxpayers Union Foundation, the Church of Jesus Christ of Latter-day Saints, the Foundation for Individual Rights and Expression, all told the court the same thing. Unenforced subpoenas chill association and drive supporters away.
Bottom line, the mere act of demanding donor identities inflicts a present constitutional injury. You don't need to wait for the hammer to drop.
Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
All right, here's what you need to know. First Choice Women's Resource Centers, a religious nonprofit, provided counseling and resources to pregnant women in New Jersey since 1985. Over 35 years of operation. The group believed life begins at conception. It did not provide abortions. It did not refer clients for abortions.
And for decades, nobody complained about that.
Right. Then in 2022, New Jersey's Attorney General at the time, Matthew Platkin, stood up a reproductive rights strike force. Shortly after creating it, the strike force dropped a consumer alert accusing groups like First Choice of trying to prevent people from accessing reproductive health care by spreading, and I'm using their words, false or misleading information about abortion.
And here's where it gets interesting. That alert invited the public to file complaints with New Jersey's Division of Consumer Affairs. So how many complaints came in about First Choice?
0. Not a single one. No one from the public filed a complaint about this group.
Yet the Attorney General still served a subpoena on First Choice in 2023.
Exactly. And this subpoena carried weight. It commanded First Choice to produce 28 categories of documents, some containing as many as 29 subcategories. And it warned the group twice that failure to comply may render you liable for contempt of court and such other penalties as are provided by law.
That alone sounds intimidating. But what specifically did the Attorney General want?
The most explosive demand targeted donor information. The subpoena ordered First Choice to hand over the full names, phone numbers, home addresses, and places of employment of basically all its donors, anyone who gave through 2 of its websites, its social media pages, by mail, in person, or any other channel. The only exception? One specific donation webpage the Attorney General considered harmless.
So the government essentially said, tell us who supports you, all of them, going back years, or face contempt.
Going all the way back to January 1st, 2021. And Platkin's stated reason? He wanted to contact a representative sample of donors to ask if First Choice misled them about its mission. His theory? Because First Choice's donation page showed pictures of parents holding babies, donors might mistakenly think the group performs abortions.
That's a stretch.
The nonprofit thought so too. 2 days before the production deadline, First Choice filed suit in federal court under Section 1983. That's the federal statute that lets you sue state officials who violate your constitutional rights. The group argued the Attorney General's demand for donor records violated the First Amendment.
And the district court denied the preliminary injunction and dismissed the complaint entirely. The court's reasoning, because no state court had actually ordered First Choice to hand anything over yet, the group suffered no injury. No injury meant no standing, and no standing meant the courthouse door stayed shut.
Think of it like this. Imagine your landlord tapes an eviction notice to your door, threatens fines and legal action. But because a judge never signed the final order, the court says you can't challenge it yet. You just sit there with that notice hanging over your head.
That's a great analogy. A divided Third Circuit panel agreed with the district court, said First Choice failed to show enough of an injury, but Judge Bibas dissented. He argued the subpoena itself, just sitting there, burdened First Choice's ability to associate freely with its donors right now.
So the central legal question, Can a nonprofit challenge a government subpoena demanding donor identities in federal court immediately? Or does it need to wait until a state court actually enforces that subpoena?
And underneath that sits an even more fundamental question about standing, which basically means showing the court that this dispute affects you personally in a concrete way. The technical term, injury in fact. You need a concrete, particularized, actual, or imminent injury, and the court needed to decide whether the Attorney General's subpoena, just by existing, created that kind of injury.
Let's unpack how the court got to its answer, because the reasoning walks through decades of precedent.
Justice Gorsuch started at the foundation. The First Amendment protects speech, worship, press, assembly, and the right to petition the government. But every one of those rights, the court recognized, carries a corresponding right to associate with others. Gorsuch put it memorably, without that right, the government could reduce any assembly to a party of one.
That's vivid. And it connects to the big precedent here.
NAACP versus Alabama, a 1958 case. Picture this. The NAACP promoted integration in 1950s Alabama. The state's attorney general, who later became governor, demanded the organization's complete membership rolls, names and addresses of every member and agent. When the NAACP refused, an Alabama court slapped a $100,000 sanction on the group. That's over $1 million in today's money. The Supreme Court reversed that judgment, recognizing the vital relationship between privacy and association and the freedom to associate.
And that case launched an entire line of decisions spanning 70 years.
Exactly. Gorsuch walked through case after case, Bates versus Little Rock in 1960, Buckley versus Valeo in 1976, Brown versus Socialist Workers in 1982, all standing for the same principle. Government demands for donor or member information inevitably deter people from exercising their First Amendment rights.
And the most recent case in that line?
Americans for Prosperity Foundation versus Bonta, AFP, from 2021. In that case, California's Attorney General demanded the names and addresses of major donors to two charities. The court struck down that demand, ruling it chilled protected associational rights, even though the Attorney General promised to keep the information confidential.
So, the precedent here runs deep. Here's how the court applied it. The court examined 3 buckets of evidence. First, the subpoena itself, demanding names, phone numbers, addresses, employers, backed by threats of contempt. Second, first choice's complaint, alleging donor anonymity held paramount importance, and that the demands scared donors away. Third, 2 unrebutted declarations, anonymous donors stating they would not likely donate, knowing their information might reach a hostile attorney general, plus the executive director warning the demands would weaken donor recruitment.
And the court found all that sufficient?
More than sufficient. And then Gorsuch delivered maybe the most quotable line of the opinion. He compared the subpoena to a sword of Damocles, borrowing from Justice Marshall's 1974 dissent in Arnett versus Kennedy. The idea, the value of a sword of Damocles. Picture that blade dangling over your head by a single thread. The value comes from the fact that it hangs, not that it drops. The threat itself creates the injury. You don't need the blade to fall.
That's essentially what the Attorney General argued, though, that because his subpoenas carry no immediate legal force, they can't hurt anyone until a court enforces them. And the court rejected that argument completely. Whether the penalties arrived immediately or depended on future court action, donors would reasonably fear disclosure and pull back. Gorsuch also swatted away the Attorney General's argument that sparing one donation webpage cured the injury. His line, "A government that takes 3 limbs but spares the last imposes an injury all the same." And allowing that logic would let governments funnel disfavored groups into narrow, government-approved channels of association, exactly what the First Amendment forbids.
The Attorney General also tried one more move, offering to narrow the subpoena and agreeing to a future protective order keeping donor information confidential. The court dismissed both. On the narrowing, Platkin's own letter reserved the right to seek identities of other donors through a separate subpoena. And on confidentiality, Gorsuch pointed back to Shelton versus Tucker from 1960. Demands for donor information burden First Amendment rights, even if there exists no disclosure to the general public. The pressure to avoid ties in speech which might displease officials remains constant and heavy.
And then Gorsuch closed with a rhetorical knockout. Would it satisfy anyone if Alabama's Attorney General in the 1950s simply promised to keep the NAACP's membership rolls to himself?
9-0. Reversed and remanded. Justice Gorsuch, writing for a unanimous court.
So let's get to our what this actually means segment. So what actually changes after this decision?
For every nonprofit, charity, and advocacy organization in the country, on either side of any political divide, this ruling draws a bright line. Government demands for donor records inflict a constitutional injury the moment they arrive. Organizations can now walk straight into federal court under Section 1983 and challenge those demands immediately. And that matters enormously because, if you recall from our preview episode, we flagged this catch-22 at the heart of the case. If the courts forced first choice to litigate in state court first, and the group lost, res judicata, meaning a final judgment blocks relitigation, could permanently lock it out of federal court. The court validated that concern directly, calling it a preclusion trap and warning that Section 1983's promise of a federal forum would die a borning under such a rule.
Think about the practical ripple effects. Attorneys general across the country now know that investigatory subpoenas targeting donor rolls face immediate federal court scrutiny. That changes the calculus before they even draft the subpoena. And the amicus support here tells the whole story. The ACLU, the National Taxpayers Union Foundation, the Church of Jesus Christ of Latter-day Saints, the Foundation for Individual Rights and Expression, groups spanning the entire ideological spectrum, all told the court the same thing. Unenforced subpoenas chill association and drive supporters away.
What the court left open matters too. This decision addressed only standing, whether first choice can get through the courthouse door. The merits question, whether this particular subpoena actually violates the First Amendment, goes back to the lower courts on remand.
So the fight continues. But first choice now fights it in federal court, exactly where Congress intended when it enacted Section 1983.
Bottom line, the government can't demand your donor list and then argue nobody got hurt just because it never forced you to comply. The chilling effect starts with the demand itself.
And 9 justices agreed. Not a single one saw it differently.
Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
And if you enjoyed this episode, tell a friend, tell a colleague, tell your barista, tell your dog. The dog won't subscribe, but honestly, the algorithm doesn't care. Talk to you soon.